Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. The defendants' first set are the appellants against a judgment of reversal. Stop. This appeal is directed against the judgment and decree dated 9/6/1998 passed by the learned 5th Additional District Judge in the title appeal, whereby he has allowed the appeal preferred by the plaintiff and the defendants, that is the respondents, and set aside the judgment and decree dated 9/4/1992 passed by the learned second munsif in the title suit. Stop. The learned trial court had dismissed the suit, which has been set aside by the impugned judgment, and decreed the suit. Stop. We shall go by the description of the parties occurring in the plaint. Stop. Para. It arises out of a suit for declaration of title of the plaintiff and defendant, and for confirmation of their possession over the suit land bearing plot number 104. Stop. The further case of the plaintiffs is that there was no partition amongst the four brothers who were living and cultivating their lands jointly. Stop. Para. According to the further case of the plaintiffs, plot number 104, having an area of 10 bighas, was recorded in land to which the ancestors of the plaintiff and defendant second set has made culturable and were cultivating for it for about 60 years. Stop. At the time of abolition of Jamidari, the returns were with respect to the land of plot number 104, including other land submitted to the state by the plaintiff and defendant second set. The state government had fixed the rent in favor of the plaintiff and defendant second set under section 5, 6 and 7 of the Bihar Land Reforms Act. Stop. Since then, the plaintiff and defendant second set are paying rent to the state of Bihar and obtaining rent receipts regularly without any obstruction and hindrance. Stop. Para. According to the further case in the plaint, the contesting defendant first set in the year 1984 put on a portion of the land plot number 104, which is situated in continuous west of plot number 103. Stop. Out of a total area of plot number 104, 2 bighas of land towards the north had been gifted to the temple of Lord Shiva, which is situated thereon, and the pujari is maintaining the temple from the agricultural products of the land. Stop. Para. Defendant first set dispossessed the plaintiff and defendant second set from scheduled land in the year 1984, when the plaintiff was in service within the state of West Bengal. Stop. The plaintiff and defendant second set, after having come to know of it, requested the defendant first set to remove the encroachment, but they refused to do so. Stop. The defendants first set filed their written statement and pleaded that some land out of plots was allotted to their predecessors on partition between the ex-landlord and the brothers. Stop. He was in exclusive possession of the aforesaid land, and ancestor of the defendant first set was his watchman and used to serve him. Stop. He settled the lands in question in favor of his watchman in lieu of his ungrudging services and put him in possession. Stop. Para. Defendant first set further pleaded that the settlement was made in the year 1921, and since then the ancestors of the defendant first set and after their death the present contesting defendants are coming in possession of the land within the knowledge of all, including the plaintiff and defendant second set. Stop para. Defendant first set further pleaded that a criminal case was filed by them in the year 1970 against the plaintiff and defendant second set, in which the learned trial court had found the possession of defendant first set and the plaintiff and defendant second set were convicted and sentenced. Stop. The conviction was maintained up to the High Court. Stop. Defendant third set also filed written statement and contested the suit. Stop. On the basis of the pleadings of the parties, the learned trial court framed the issues for adjudication. Stop.